How are you?
Well, clearly not that great if I just muted myself on something live. But
That's
anyway.
because you were complaining about pain.
Yeah, that's.
I
shouldn't complain. I'm generally not a complainer.
How did the training go?
Yeah, intense. The great thing about finding the right trainer is that they know you, and she now knows me so well that she knows all the areas to push, which is great. So I'm exhausted by the time I'm done.
Well, Danny knows me. He's been training me for 15 years, and as you can see, with little success. Sorry, Danny.
He does tune in.
I don't know, anyway. But he saw me today, and he goes, "So it won't be a really hard one today." And I said, "I'll kill you if you try."
You should get me to train you. I would make you work so hard, and I'd get so much joy out of it. I'll tell you. Yeah. Anyway.
Yeah, you got to get up early to train me.
Yeah.
Been fun driving in the country, seeing clients, hasn't it?
Yeah,
it's catching up with you in Warrnambool, which was a bit of a surprise as well.
Yeah, a bit of an unpleasant surprise for me, but anyway. I'm on fire.
You are on fire this morning. You need to let it go.
Yeah, okay, fine. No, it's great. I think it's, for me personally, my favourite thing to do, being out on client sites and just being in, on clients' environment, their space.
It's nice to be outside of the city. I mean, 50% of our client base is regional. It's lovely to be out there and actually see them again. And we better kick off. It's time. I'm the clock watcher here.
Okay, fair enough. Let's go. Alrighty.
All right, so let's kick off here. Probably the first thing to talk about is what's happening in the case law. Okay, been two really interesting cases. The appeal against Commissioner Reardon's decision in Knowles and BlueScope came up. That's where a long-standing employee was terminated for breaching a high-risk process, which was a mandatory risk. Interesting, like is so often the case, commissioners don't know safety law. And Commissioner Reardon said, well, nobody was in the line of sight, so it's not really a safety incident, which of course is complete guff. The fact is, if you do an incident that involves a serious risk and you breach a duty, it's the same as if you hurt or killed someone. That's what a primary duty is under safety law. And the full bench, which is a bit better educated, just said, oh, it's just absolute nonsense. It's incredibly high risk. The policy and procedure cast it as a high risk, so the analysis had been done and made it as a mandatory rule because the risk was so high, they needed 100% compliance. And so the termination was upheld. But it really comes back to this issue around policies and procedures that we deal with all the time.
Yeah, absolutely. And when it comes to risk, when we had a chat earlier this morning, it was about there's this misconception around actual risk versus potential risk. Right? Just because they didn't get killed or they didn't get hurt or they doesn't mean that they couldn't, because the risk was there. The question is, in terms of your workplace, do you know what your critical risks are? And that's obviously underpinned by a risk assessment that's done for the organisation. And when you know what they are, there are rules in place, and regardless of whether people get hurt or not, or how hurt they might get, it's irrelevant. You still got to manage it really.
Well, Karen, the amount of times we walk into places where off-the-shelf policies and procedures are loaded in with no risk assessment behind it, no priority of risk. So people don't know what is the big risk they must manage. If you look at Australia's fatality performance over the last 40 years, is what you see right down to 2 years ago is a continual, very satisfying decline in the amount of deaths and serious injuries that occur. But in the last 2 to 3 years, we've seen that going back up again. And the reason for that is, A, the sample's growing, but more importantly is very, very high fatality risk, but low frequencies are being missed because there's total focus on the zero harm sort of mentality. Remember, your policies and procedures must be based on risk, and where the risk of non-compliance is high, there should be golden rules. So look, great case, really interesting case, and well done for the full bench for actually understanding how safety law integrates in with workplace law. Next case is a fascinating case. It's the Compass Group, which is like a spotless type of organisation that provides labour forces for fixed term contracts, whether it's in catering, cleaning, security, whatever it is. And they moved for a variation of their enterprise agreement because they were competing for a new contract. And as part of the FAQs, which they're obliged to do to get the variation across so people understood, they said, look, if you don't support what we're saying on numbers, then we will not get the contract and we'll have to immediately demobilise our workforce. And under those types of enterprise agreements and awards, that means there is no redundancy payment. So they're very honest about the fact if we don't get the wages we're talking about, they're clean about their numbers to show how they got there. If we don't get it, we don't get the contract. We've been told we won't get the contract and you'll be gone.
No, that's not scaremongering.
No, that's just truth. Just truth. And the union said, well, it's a general protections type of argument. It's coercive. It's wrong. And the court said, well, that's just crap. Like, you're just being honest with people, and you need to be honest with people. It's actually a good thing to be direct and sincere. And again, how often in the enterprise agreements you and I are dealing with, we come to the 11th hour and everyone says, oh, it's been a very bad year. You can only get 2%. That's dumb. Okay, because that doesn't even suggest a good business case. Knowing your numbers and being candid with your employees so they know the outcome, absolutely critical.
Yep, I agree with that. And knowing more, it's actually more than just your own numbers. Knowing in terms of your operating environment, in terms of your sector, your industry, what's happening, your region. You need to know what's happening in terms of appreciate and consider what's happening at a macro level across the economy. These things might actually serve you in terms of demonstrating supporting your business case.
And make no mistake, your clever employees know the margin you get. So trying to hide this stuff, if you're a 12% margin business and you say, if you want that, it reduces our margin, and it's true, no one says you can't make a profit. That's not what it's about. Yeah. So be really careful. But as Karen, and we've just done some enterprise agreement work between the two of us recently, where we've done all that analysis and we've come up with a better outcome for the employer and for the employees in the process, because it's interest-based, the flexibility we're trying to achieve. Anyway, look, really good. Now, what we'll switch over to is what I'm not allowed to, I haven't got a name for this segment yet. Have you got a name for this segment?
Maybe, I don't know. I think we had a couple of suggestions last week. We've got to look at them more closely. Maybe if it's going to be HR dominant, maybe we should call it like All-Star HR or something. I knew that.
Well, maybe not, Anyway, Karen, it's over to you.
Until to be determined, okay? It remains.
Keep putting in your suggestions.
It remains unnamed for now. So yes, what I wanted to do this week was look. The last March, there's been a tremendous emphasis around women at the workplace and women's rights and gender equality with International Women's Day, but also last week's March for Justice as well. So. Obviously, there's a lot on social media, a bit in the news, and I think it's fantastic that more than ever that there's dialogue around that. What it inspired me to do was more, well, what do we do with that? I mean, organisationally and for employers, like what questions do we need to be asking ourselves? Look
at the question you've asked when we set the business up, which is, well, look, if we say we're diverse, what does that mean? And treat it like a right, not like an argument. So if we say we're diverse, that involves men and women, involves a whole range of different people, that involves different nationalities, different gender identities. If we say we're diverse, and by the way, we must say we're diverse, that's a moral issue for me, but it's actually a legal issue, which we must be diverse. What does it look like? And you became the architect of that in our business.
I'll take that.
Yeah, we built it, but she was the architect.
Yeah, that's right. I'm the face of it, right? Anyway, so
stop it.
So with that, look, with the slide pack that went out this morning, just two infographics for you there. One, I just wanted to highlight where we're at, what the state of play is in 2021. The pay gap still globally is sitting around 23%. We're seeing that there is unconscious bias is still quite rife, not just with men, but women themselves, in terms of this idea that men are going to be better leaders and are just more effective. So there's a few other facts in there as well that are interesting. The one that kind of was a bit depressing for me was based on the World Economic Forum, that their prediction was that it's going to take us another 100 years before we get to this gender in terms of parity equality, which is shocking. How am I going to explain that 5 generations down that we didn't do something about that, at least be part of that change? So taking it back to the workplace, though, in terms of organisations, there are a couple of things what are the contributing factors that lead to where we are today? And so there are a couple of things, and I've highlighted them. They're not all, and I'm sure there's many others, around flexible work arrangements. There's around in terms of actually reviewing pays and doing audits in terms of pay between across your workforce. I'm not just talking about gender too. I'm talking about different in terms of diversity, in terms of different groups as well. We're talking.
Can I just say the 7-Eleven cases when they came through about underpayment? So the series, just not other franchise organisation, it invariably was a particular racial group who was working for wages which were beneath what was lawful. So remember, gender biases, not just gender, they're racial biases.
Absolutely, and it's a much
the world
bigger,
is rich with those sort of biases.
Yeah. And the way I frame it in terms of those biases, what I really want to how I want to focus it on, like we talked about this morning, gender inequality, because now I want to focus on getting to gender equality. Okay?
Yes,
And I know they're just words, but because we are the same, there is nothing that separates us, aside from physical attributes and characteristics. The rest of it should be irrelevant, but it's not relevant, right?
Yeah.
So other things like parental leave, in terms of how we support parents as well. And I don't even I'm not talking about women, I'm talking about men too.
Men as well.
So there are things in there that I guess there's a series of questions that hopefully your organisation might already be doing something quite active. And if you're doing something, I'd be really keen to learn what your strategy is, because strategy, it's reported that
I think we both love to know.
Yeah.
Because I a lot of the times when we're talking about this with clients, it's very hard other than taking out what we do and the surveys that I've read, which I keep reading. But I'd love to have stories or testimonial stories. I could say, well, go and speak to Christine about this because they're doing this, and this is an electrical business, and she'll actually explain what they're doing so that people also build up this support network of people.
We need more of those stories.
We do.
Yeah, because we know the stats already. We know about the issue. We need to be encouraged to keep taking that step in the right direction.
Yeah.
So anyway, and in terms of a couple of examples of organisations who are leading in the space as well, and what I didn't include was FCW. So and I do remember during when we did start this, in terms of setting the policy around parents, we were saying, well, what are we going to do around parents? And one of the things that FCW has got in place is around, we provide paid parental leave at full pay, inclusive of super, because see, sometimes when people say that, we pay people, but it's at minimum wage. So for 4 months. So mum or dad, that's what we do. And that's quite uncommon, particularly in the legal sector. So,
which is odd when you think in the legal sector, the level of demand against what you do in your life. If I think about finishing my emails last night, and all my staff were finishing off bits of work later in the night, we assume and expect so much from people. Where's the investment that says, but we return it? We want you to be with your family. We want you to be a good parent. It comes back. We get that investment back immediately, but you've got to have these really honest conversations with people. And I think our flexibility approach has worked. It's been, when you helped me with this, because you did, because I'm old style Protestant style worker, which is come to work at 7:30, leave at 7 o'clock at night, because I'd spent 30 years of my life working in law firms where that was the practice. Well, it's liberated me. Can I say, I feel I'm much more competent at what I do, because I don't assume I will be somewhere at a particular time. I assume I will get work done by a particular time. And it's lovely. I get to say goodbye to Gail every morning before I go to work. And for 13 years of our marriage, really, I had not seen Gail in the morning before I left for work.
Yeah. So you see this is what you're talking about, is some of the unforeseen benefits of these type of, thinking about these type of things. So look, I hope the slides are useful. I hope some of the questions that we prompted there are useful for you. But if you're working in this space and got some deliberate plans or strategies, would love to learn about what you're doing.
Yeah, and always happy to share too. They're not things that we're going to clip a ticket on the way through and charge you for, but we do want to learn. We want to be better. We want to bring different ideas into our own business, but also to be able to share your successes. And hopefully you'll let us connect with people who are actually challenged in these conversations. How did you navigate it? What could you do to help?
Yeah.
Let's move on to the next issue, which is restructuring. And it's the first part of our analysis around restructuring. We'll probably do this in 3 parts. But what I want to do while I've got Karen here, and maybe Sophie, if you could pull up the slide, is to look at what you do before you restructure. So we'll talk about what happens next week. What is the law around actual redundancy in about 2 weeks' time? But I think next week we'll do the process of actually what you do in a restructure. These are the 5 key things for me, okay, is actually analyze what your business case is over the next 3 years and then segment it into the chunks of change that's going to happen. And look very carefully at what is the capability that you need to deliver that, and what are the business opportunities if you do it well. Because what people think about when they do a restructure is, oh God, this is going to be hell. When you change something big in a business, there is enormous upside, because you're turning an organization on itself. And therefore, there's lots of opportunity to change that come with it. Now, that means really careful planning, so that change is aligned and people feel that they have ownership in that change and they're not scared about it. So know your business case, identify the opportunity, then go through meticulously and identify the capability of change during those chunked up segments over 3 years, so you know what is the people capability that you need. Now, we've talked about this so often, about relentless redundancies, where every 6 months we do a minor restructure here. It's actually laziness and it's cowardice. In other words, I'm not willing to take a deep cut and then work out how to do it. I'm just going to keep chipping away. And what we see is productivity goes out the door, trust disappears, people hide for fear of being found.
Mm-hmm.
And so it's crazy. So what I want you to do is to look at it that 3 year and then cut very deep once. And then look at methods of engagement to have the flex that you're going to need before you go again. And remember, when you plan one restructure, you should plan your next. So you should go, we're going to get to this stage and we are going to have to do this. But in between that, I'm going to use choice of labour, choice of capability, contractors, subcontractors, gig people if necessary, casual labour. What am I going to do to get there? Because I don't want to go a death through 1,000 cuts.
Yep.
It's only when you've done that you get to number 4, which is, okay, now I know the capability I need. These are the people, I need a group of people who stay constant, who feel safe and are absolutely committed to me. Okay, now I can start structuring the matrix. And I guess, again, as we're walking back from our morning coffee and brekkie, I was saying, and one of the issues is when I come to do restructures, and you recently chatting to me in an organisation you're dealing with, people start to roll in a few people they don't like as well. Now, you make your own value decision about that, but if you do that with me, please do that under privilege. And we normally do that, and Karen and I both do it, through running a privilege training session with key decision makers where we go, high risk people, middle risk people, low risk people, capability down here. Okay, it's only then I can build a matrix with you, which is a defensible matrix in the Fair Work Commission and the federal court that says these are objective methods that we can deal with, which may capture some of the difficult problem children that you've got out there. But that's not why we do redundancies, okay, or restructures. Now, if you want to roll it in, whatever happens, until you've done the first 3 parts of this analysis, you can't develop the matrix. And if you don't have an evidential matrix to measure people's capability by, you will fail terribly through dispute procedures under awards, through redundancy attacks, all of it, and you probably could end up in the federal court in respect of it. Now, the last part is evidence planning. I know this sounds like dumb, but you only want one decision maker, because if you're going to end up in court, you want one witness. If it's a general protections risk, as it commonly is, because there's a union delegate in here, there's a person who's got injuries in their protected attributes, so you're running the gauntlet of general protections when you do it. Certainly since Barclay and Bendigo tape, it's very clear we quarantine that decision maker, so they only know the evidence they know, so their only decision is for a proper reason. Be very careful about the documents you create. If we're going to go through this process, what Karen and I will do with you is say, well, let's get the strategic structure right first under privilege. Let's help you build the evidence, which totally guarantees the business case that sits behind it, and identifies who is the decision maker, and the subjective reason for the decision is clear, because that's the test under general protections. And that means when you go into dispute, you can prove it. And the last part is you must, at the very beginning, say, what does the definite decision under the award or enterprise agreement, because that kicks off the consultation provisions. And in big disputes, that's where you're drawn into. You're drawn into an application in the federal court, in the end of which says you breached the consultation provisions, and then all the allegations and all the applications for discovery come out. So the very first thing you say is, what would a definite decision be in respect of this process? And it will be a decision that we are making a restructure that would affect this group or part of the business. Okay? So we put that at the front and we start this at the back, and we say, well, what would be the proper consultation process internally in the organisation, which brings in numbers, brings in capability, brings in sales and marketing. When we get to here, that's the definite decision, because at that date we have to consult with the unions and the affected employees. Under Deacon's case, we have to consult across the organisation as a whole. So not understanding what is a definite decision embroils you in litigation. So it's the first thing you put on your list. This is what a definite decision looks like. This is the business case, and we build it. And with Karen and I, or whoever you're using, you build that knowing it is an evidence trail that proves subjectively From one decision maker, there was a good business case, and that was the reason. Okay.
Sound business case, sound process, and if you are considering a restructure in your business, it is really, if I think you need to engage with somebody, whether it's you, I, or somebody else, but great idea to have a conversation about your preparation for that, so that you're in the right mindset, but you're also in terms of asking yourself the right question and set out a process that will allow you to do it with minimal disruption and issues.
And you're stopping all the wrong communication.
Yeah.
So you're saying to the group, I don't want to see your texts and emails. Why don't we get rid of this guy? I don't want to see that. Yeah. I want us to be clean.
It happens often.
It's all the time. And it comes in Discovery and you read it and you know you lost the game. You know, as soon as that, I have to give that up. And it's so often texts. You know, the texts go, well, let's get rid of this prick. I've had enough of him. He's the delegate and he's driving me crazy. That just burnt the whole process. Yep. And that leads to personal penalties, corporate penalties, injunctions. And that's a huge cost. And you don't get what you wanted. Yep. You're back to the beginning. So what I've done today for you is I've given you a really complex problem. And Sophie, if you could bring up the problem, that'd be great. I'll read this through because it is a complex problem. And I'm sorry about that, but I wanted you to understand how bad something could go. Does that make sense? And this is a very common problem for an Australian-based subsidiary business, an American or a European business. So Glow Lights Proprietary Limited is an Australian subsidiary of a New York Stock Exchange listed LED light manufacturer Glow Inc. Glow has decided to cease manufacturing in Australia and supply products from its Malaysian manufacturing site. All that will be left in Australia is the warehouse, sales and back office. The decision to cease manufacturing was raised by Randy Greenback, Group COO, in February 2020 at the Global Executive Meeting. He gained approval. Randy did not need board approval to close the local manufacturing site. Hence, it was not a disclosable event on the stock exchange. Now, that's incredibly common, can I say? So it's held within an executive group who do have the powers to do it, and it's not something that needs to be disclosed in ASX, which means it stays a secret. By March 2020, Randy had gained agreement from the global manufacturing vice president, and shortly after, Malaysia introduced and commissioned 2 new lines to meet the Australian demand. By October 2020, everything was ready to roll in Australia, but COVID frustrated the rollout. The Australian CEO and local board had signed a non-disclosure agreement, again, incredibly common that local people have to sign an NDA, with Glow around the change. Had been consulted all the way through, but actually had no power in any of the decision making. So can you see already what we're talking about? The decision making doesn't exist in Australia. The AMW had an EA on the Australian site. They had an international exchange of Asian Union organisers as part of its support of Asian unions. A Malaysian organiser on exchange to Australia after his 14 days of isolation told them the scuttlebutt around Malaysia was they're closing the Australian site. Donna Duchess, the AMW organiser, approached Don Fries, the local CEO, and he's also the board chair. Again, very, very common that the chair of the local company, because you must have a company operating in Australia to have a subsidiary in Australia, and asked if it was true. Don freaked out, I put out in there, and said it was gossip and refused to answer any questions. The union made an application to the federal court, alleging breached the award consultation provisions. A definite decision had been made, and there was no consultation, along with claims of general protections breach. There was no real financial upside as a result of the current price of Australian dollar. And this is a real problem with overseas businesses, that at times the Australian dollar takes out all the immediate benefit. And Glow would make money on hedging, because remember, the Australian businesses will hedge money, and often you make money on the hedging that you've done. I know you don't think that's relevant. Can I just say, in 3 out of the last 6 cases we've dealt with, this comes from cases that I've dealt with, okay? In the long term, the expected change in the dollar may be good for Glow, and that was their expectation. It helped reduce labour costs for the Australian business and meant worldwide they were de-unionised. Randy had commissioned a report from EY in Australia that explained all these things. And I reckon that's poll time, guys. Here goes the poll. Let's go. We need poll music.
What is that?
Some music, something like in a lift.
I'm thinking maybe, what is that tune from the Muppets?
Remember, you're the one with the young children. Right?
No, Muppets. It's more like when you were a child.
I don't know. Can you sing it?
That one,
yeah, Sesame Street.
No, I don't think it is.
Yeah, it is. It's Sesame Street. No, we've never.
Now, okay,
No,
now people are going to write to us and tell you.
Could you tell us what is the song from the Muppets, please? What is it? A polka, perhaps. Yeah, a polka would be good.
You dancing to that?
This day tonight. You're exactly right. That's where I got it from.
There you go.
Are so. Who said that?
Jeanette.
Jeanette. Well done, Jeanette.
Thanks, Jeanette.
I think we're distracting people from the task.
Okay.
30 seconds.
Okay, that's right. Maybe not 15. Mastermind. Yeah, we could, Margaret. All right, 3. Oh, the baby elephant walk. Always good. Yes.
Yeah, I agree.
Okay, we're going to wrap it up there in terms of the poll.
Okay, lock it down. Very good. All right. So the first question is: had a definite decision to cease manufacturing. I could actually read this from my own thing. It would be a good thing, wouldn't it? Had a definite decision, CP writing, had a definite decision to cease manufacturing in Australia been made under the award and the EA? The answer is absolutely. The definite decision is not the sign-off of stopping, it is that a decision has been made. Okay, so it's not the act that follows the decision, it's the decision that is a definite decision. And people keep forgetting that. And if you don't do that, it's actually a civil penalty breach. So there was definitely a decision that has been made. And look, it's great people have thought this through, because again, I know I do this and I'm naughty. This is a legal issue and nobody ever understands it. And that's why I said to you, you plan the definite decision at the beginning of the strategy. You actually characterize what that is. So thanks, guys. And I'm sorry I do that every now and again, but it's just to highlight that the law does have something to play in this. In the federal court proceedings, was Randy a compellable witness? Yes, after the Substitution and Execution Process Act, you can subpoena, the union can subpoena them. Worse still, Randy is actually the decision maker, so you would have to call Randy, because that's the subjective decision maker. And if you don't call that, then there is case law that says your failure to call that person will be assumed that that person would not give good evidence for you. Okay, it's pretty devastating, isn't it? Okay. All right. The next question is: could the EY report be discovered in a court case? It would have to be discovered. You would have no choice about it. It wasn't done under privilege. Okay. And can I say the nature of the gaining of that report in these circumstances may not allow privilege to apply either. So how you get advice on these things has to be carefully characterised around the risk of litigation particularly. So that's another issue that it's great, and we constantly use accounting firms, including the top 4, to provide us advice around what is the financial case for it, because the financial case is usually 3 to 5 years out. It's not usually 1 to 2 years out. The Fair Work Commission isn't, and the federal court to a degree is pretty unsophisticated a lot of the time around financial matters. Therefore, they just don't get it, that you're doing something, you're going to take a loss. There's actually a capital loss that you can actually accrue. They don't get that, and it's very hard, in the commission, almost impossible to explain it. Is there an arguable general protections claim? Can you roll down and see what people have said, because I can't see it.
Yep. So, give me a second. There we go.
I think there is, yeah. So I put that in because the deunionisation would be in the EY report. And so the spread of people answering this is actually really good, because I'm not sure a general protections claim would get up, but remember it's a reverse onus. So once they allege it, you have to prove it wasn't for deunionisation. The EY report says it's a benefit to be deunionised. So you've got a substantive purpose being elevated, and you've got a report that doesn't say there's an immediate financial benefit. Therefore, if the substantive purpose is deunionising, you're in real strife. And if the objective evidence, when you read it, suggests, well, I can't see the financial case, then you've got a really uphill job, and you must call Randy. But then Randy is going to have to call other people from overseas. Do you see what's going to happen very shortly? You've got a case that could take a day if it was run in Australia, and you would win easy, and you're now up to a 3-week trial that's going to cost you $1 million. You're going to expose your global executive along with a whole range of documentation which discloses all sorts of commercial stuff. Now, remember that you can't be forced to disclose commercial in confidence. except for the purpose of discovery. And you can be, and you're not allowed to use that externally. But of course, it always is, because it's knowledge in the litigator's hands that they subsequently utilise. They don't quote it, but they're into you straight afterwards. So I did this case because I wanted to show you the importance of strategy. And never to be caught by the impulsive need, let's do a restructure. Never to be caught by the immediate business imperative, look, we're going to close this plant down, so let's get on with it.
Yep. So again, takes it back to the point is that if you're thinking about or considering a restructure, get some advice first.
Yep.
Don't start talking about names and who and what jobs. Don't even go there. Just,
names are last.
Yep.
Names are absolutely last. What we're looking at is capability. And if you've got some dirty stuff to do, well, that's why I wear rubber gloves. Now, next week, we're going to talk about the process and redundancy and restructure, so you know exactly what it looks like when you roll. And the week after that, we're going to look quite deeply at the employment law issues behind redundancy, so you understand it. Now, there's a big question, I think, that's come out there. I've found US corporations have a fundamental assumption of how they do. Yeah, Kate, you're absolutely right. I mean, remember in America, enterprise agreements came in the 1930s because all employment is casual. And so Americans assume you can just stop things. You can just terminate people. So it is a mindset they have. And they'll close whole businesses to close out enterprise agreements. They're quite used to doing that. And although it's a highly litigious economy, it is a very split economy. People are much poorer. You know, the manufacturing rate in America is $11 an hour. So,
yeah,
you know, it's a different economy to ours. So, look, that's great. That's this week. It's really great to catch up with you again. I'm not sure I'm here next week. I think there may be a fill-in.
Oh,
so I need you to
okay.
rate next week. If it's Matt or Kim, bag them. Please bag them.
Oh, I'm going to have so much fun. Really good. From a bounce perspective, next week we'll create something around the restructure piece as well. So probably a tool for you.
Yep.
So that will help you.
Okay, guys, we got to run because we're right on time. Thanks again. Lovely to catch up.
All right, take care. Bye now.
Bye-bye.